Is India's bankruptcy law being misused to sell corporate assets cheaply to insiders? The Chief Justice of India says the problem is real and serious. Hello everyone, welcome back to our channel. This presentation is brought to you by Synergy Business Advisors Noida, your trusted business mitra providing complete advisory solutions. Today we are discussing the latest Supreme Court observation by Chief Justice of India, Mr. Suryakant, who raised a strong concern that the Insolvency and Bankruptcy Code is being misused by some companies, leading to undervalued asset sale to family members or close associates. Background: the matter came up during the hearing of a public interest litigation filed by former Union Secretary E.A.S. Sarma, seeking a court-monitored investigation into alleged bank collusion in the massive Anil Dhirubhai Ambani Group loan fraud involving over rupees 40,000 crores. What the CJI said: the Chief Justice expressed that portions of the IBC proceeds are being misused. He pointed to cases where assets of bankrupt companies were auctioned at a very low valuations, sometimes even to family members or close associates of those in control. He described this as a pre-planned game. Companies declare insolvency, undervalue assets, and insiders buy them cheaply. He further added that unfortunately, the IBC platform is now being misused like anything. Somebody from the family or close friends comes and buy it. The Chief Justice's concern about IBC being misused and assets being sold to family members or close associates can be directly linked to the following pattern seen in some insolvency cases. First, after a company defaults, banks sell stressed loans to an asset reconstruction company at a discounted value. Once the ARC acquires these loans, it gains majority voting power in the committee of creditors. Thereafter, a front company or connected entity of the original promoter submits a resolution plan. Since the ARC effectively controls the COC, the resolution plan is approved in favor of the promoter-linked entity, often at a significantly undervalued price. In certain cases, instead of routing the process through an ARC, banks themselves extend support to the promoter to avoid ARC involvement, while still enabling the promoters or related parties to regain control of the company or its assets through the IBC process. This entire arrangement allows assets of the corporate debtor to be transferred back to the promoter, relatives, or associates at throwaway value, which is precisely what CJI cautioned against when he observed that the IBC platform is being misused and that assets are being sold to family members or friends. The council pointed out that Reliance Communications and Reliance Industries, with outstanding dues of around 47,000 crores, were effectively transferred for just 455 crores, which was about 1% of total liabilities, and that the buyer was linked to the promoter's family. The CJI observed several troubling patterns disturbing trends in the way insolvency proceedings are being used. In many cases, companies voluntarily enter bankruptcy without obtaining independent and credible valuation of their assets. This lack of transparency often leads to assets being priced far below their actual market value. Alarmingly, some assets have been sold at valuation as low as 10% of their fair value. The court also noted instances of sham or non-competitive auctions that failed to attract genuine bidders. As a result, insiders, relatives, or close associates frequently acquire valuable assets at throwaway prices. Such practices defeat the core objective of value maximization under the Insolvency and Bankruptcy Code. The repeated appearance of these issues before the Supreme Court indicate systemic misuse rather than isolated irregularities. Government's response. Solicitor General Tushar Mehta informed the court that the Government of India is seriously considering this misuse and is part of ongoing discussions on how to address it. The Supreme Court also criticized the CBI for registering only one FIR based on complaint from a single bank instead of separate FIRs for each complaint. Not investigating alleged collusion between bank officials and corporate stakeholders more thoroughly. Directing the CBI to explore whether bank officers may have colluded in these undervalued transactions. What is at stake? Undervalued transactions. The IBC contains safeguards like Section 45, which allows reversal of transactions made at values significantly below market price. Such transactions, if found to harm creditors, can be set aside by the adjudicating authority. This provision aims to prevent promoters or related parties from siphoning off value before or during insolvency. Fair valuation. Valuation under the IBC must be conducted by independent and registered valuers using objective market-based methods. Any influence by promoters or connected parties compromises the integrity of the process. Fair valuation is essential to achieve the IBC's core goal of maximizing asset value. Number 3. Avoidance of collusive auctions. The insolvency framework requires auctions to be transparent, competitive, and open to genuine bidders. Collusive or sham auctions reduce competition and lead to assets being sold at a throwaway prices. Strict checks on conflicts of interests are necessary to ensure credibility and fairness in the resolution process. To prevent exactly this kind of misuse, the Insolvency and Bankruptcy Code introduced Section 29A. This provision disqualifies defaulting promoters and their connected persons from submitting their resolution plans. The law is clear. A promoter cannot re-enter the company through the back door, whether directly or through a front company, relatives, or close associates. However, the Supreme Court's concern highlights that creative structures and indirect controls are sometimes used to dilute the intent of Section 29A, allowing insiders to regain assets at undervalued prices. Key takeaways. The Supreme Court acknowledges possible systemic misuse of IBC process. There are ongoing concerns about undervalued asset sale to insiders. Government and judicial scrutiny are intensifying to protect creditors' interests. Transparent valuation and genuine auctions are critical for credibility of the insolvency framework. Conclusion: as India's insolvency landscape evolves, it is vital that the ABC maintains its original purpose, that is efficiency, fair resolution of stressed assets without eroding value for creditors. This is C&IP Praveen Agrawal thanking you for watching. I hope this presentation will be helpful. Please subscribe to the channel for more such informative videos.